This is Amanda Kay. I'm a senior program attorney at the National Council of Juvenile and Family Court Judges, and welcome here today for our program, Should I Stay or Should I Go?, which and where we'll be talking about interstate custody and relocation issues that domestic violence survivors encounter regularly. For today's program, we welcome Deb Goldman and Jenny Lohr from the Legal Resource Center on Violence Against Women. This is a nonprofit organization dedicated to improving legal representation for domestic violence survivors in interjurisdictional custody disputes. Deb Goldman is the executive director of the Legal Resource Center and has a lot of experience representing survivors in civil legal matters, including custody. She's also worked for the ABA Commission on Domestic Violence and OVW. Jenny Lohr is the project coordinator at the Legal Resource Center and has many years of experience as an advocate assisting survivors, including overseeing the operation of hotlines. With that, welcome to both of you, and thank you so much, and I'll turn it over to you.
Thank you. Good afternoon, everyone. I'm Deborah Goldman, the Executive Director of the LRC, and here with Jenny Lohr, as Amanda said. Thank you so much for joining us this afternoon for our webinar on interstate custody and domestic violence. And we also want to thank you for what you do every day helping domestic violence survivors. We have many advocates from across the country on the line, and we know that so many of you receive questions from survivors about whether or not they can move across state or tribal lines with their children. We also thank NCJ-FCJ for hosting this training. We really have two objectives here today. One, to introduce you to the Legal Resource Center on Violence Against Women and let you know how we can support your practice. And number two, to spend some time on the nuts and bolts of a particular law called the UCCJEA, the Uniform Child Custody, Jurisdiction, and Enforcement Act. That's the law that says which state has the power to enter a custody order out over a particular child. We're also going to have some time for questions and answers, and we're briefly going to touch on relocation and parental kidnapping laws, which also come up in these interstate cases. So we imagine that the kinds of interstate issues you're hearing about from survivors are very similar to the issues we hear about on a daily basis from survivors. You may be seeing cases where it's the parent who has been abused who takes the children out of state to protect herself and the children. Perhaps she's fleeing to a different part of the country where she has support from her family of origin or a safe place to stay. You also may be hearing about cases where the parent who has perpetrated the abuse has taken the children across state lines to punish the former survivor, perhaps disappearing with the children or violating an existing court order. And finally, you may see cases where two different states have issued conflicting court orders regarding the same children, perhaps a protection order in one state and a custody order in another state. Or perhaps there's an issue of enforcing a court order that was entered by one state, but trying to make sure that a judge or law enforcement in a second state is obeying that custody order. So we're going to touch on all of those topics here today. And to start out with, Jenny is going to share with you a little bit about how we can support your practice.
Hi, everyone, and thanks for sharing, and thanks for joining us today. So we believe that domestic violence survivors should not have to choose between fleeing from their abusers and retaining custody. However, we've encountered many survivors who manage to escape violent relationships but lose their children in subsequent custody cases. And that's where we come in. The LRC is working to change this by training attorneys, advocates, and court personnel to improve legal assistance in interstate custody cases and to provide information to survivors and the professionals who assist them. So when is it appropriate to call or refer a survivor to the LRC? Please feel free to call us or refer survivors to us if the case involves domestic violence, if there is a child custody issue, or if the case involves more than one state, tribe, or territory. As Deborah mentioned, most cases referred to the LRC are because the survivor is thinking of fleeing the state with children to escape violence, or the survivor has already fled the state with children to escape abuse. and we encourage all LEV grantees and others to reach out to us for assistance on these cases. Please note that we do not handle international cases, nor do we directly represent survivors. We can assist survivors in finding civil attorneys when a jurisdictional legal issue is involved. And the types of services that we offer, we operate a hotline during our business hours, 8 a.m. to 4 p.m. Eastern Standard Time, and we talk by phone daily with professionals across the country who have questions on the law involved in interstate cases, including advocates, attorneys, and court personnel. We provide attorneys with sample pleadings and case law summaries, and our staff attorneys can help strategize about cases. We provide advocates with legal information and referrals. And for the survivors who call us, when there is a jurisdictional question, we can help them find an attorney using our database of attorneys and programs across the country. In addition, we maintain a website with jurisdictional and related laws that anyone can access on our website. You'll see here a list of tools we've developed over the years for attorneys, advocates, judges, court personnel, and survivors that span across disciplines to ensure that this important legal information is meeting those who need it most. And the FAQ on relocation for advocates is one of those tools we've helped develop with NCJ-FCJ, and that is available for you all today in the webinar room. So we imagine many of your programs encounter situations such as the one we're about to discuss from domestic violence survivors. We will use this scenario throughout the webinar to help illustrate a typical situation we may see. So in this situation, Lila Smith calls you at your office in Nashville. She is calling from her car while driving to pick up Philip Smith, her husband, from work, and only has 5 minutes to talk. You learn in the brief conversation that Philip and Lila have been married for 5 years and have lived in Nashville throughout the marriage. They have one child, a 7-month-old daughter named Annie. Philip has physically and emotionally abused Lila since shortly after they were married. Philip has never been charged or convicted criminally for the abuse, and Lila has never sought a civil protection order against him. Lila thinks a neighbor may have heard the abuse, including the most recent incident, which took place last week. During that incident, Philip held a gun to her head in front of Annie and threatened to kill her. Lila tells you that she wants to leave Nashville and move to California, where her family lives and where she hopes to find a job.
Thank you, Jenny. So now we're going to dive into some of the legal issues that come up in these sorts of relocation cases. And our goal is to really introduce you to these issues, not to make you experts on the various laws that are involved. So when you talk to survivors, like Lila in this case, one of the first questions that comes up is there a previous custody order that has been entered regarding the children? The reason that matters is because if there is a custody order, whether it's a joint custody order or the perpetrator has received some type of visitation under the order, that can really hamper a survivor's ability to leave the original state. So, for example, you would not want a survivor like Lila, if there was a custody order in place, to leave and violate an existing court order. That could expose her to charges for contempt, and even in some courts across the country, it could mean that a judge would think about changing custody to the other parent. So that's critical. Another issue that comes up daily for us at the LRC is whether or not a survivor would be violating the criminal law in the state that she wishes to leave by taking the children across state lines. So for all of you who are advocates on the line, please check in with attorneys in your neck of the woods to find out what exactly your parental kidnapping law says in your state. And we'll talk more about parental kidnapping laws later today. You should know that many of these state laws do have some protections embedded in the law for domestic violence survivors or for parents who are fleeing in order to protect their children. And certainly at the LRC, one of the primary reasons we see folks fleeing across state lines is to protect their children from ongoing physical or sexual abuse. Another separate legal issue that comes up is whether or not a survivor needs to comply with something called a state relocation law. And we will talk about state relocation laws briefly today, and I know that NCJ-FCJ will also be hosting a webinar in early August dealing with legislative changes and addressing some state relocation laws there as well. A separate issue that comes up for some folks is, are there some immigration-related consequences to leaving the state? So, for example, if Lila was a battered immigrant woman, there could be some additional hurdles to consider regarding leaving the state with Annie. For one thing, it could be especially important not to be charged criminally with parental kidnapping because of the connection between having a criminal conviction and potentially being targeted for suspension proceedings or for deportation. Similarly, if there are concerns around immigration and Lila could potentially be eligible for some immigration relief that's available for domestic violence survivors, that may mean that it would make perhaps more sense for her to file something like a protection order before leaving the state. So I'm thinking about specific forms of immigration relief that are available. For example, under the Violence Against Women Act, a self-petition is available to a domestic violence survivor who is married to a United States citizen or lawful permanent resident and meets certain other conditions. But in order to apply for self-petition and have a finding that someone is eligible for it, the history of domestic violence has to be proved. In Lila's case, with the hypothetical we gave you, and in so many real-life cases, there may not be a lot of documentation of the violence within the criminal justice system or the civil justice system. So getting a protection order before leaving the state for someone who is an immigrant survivor may then be helpful in accessing a form of relief like a self-petition. Similarly, if a domestic violence survivor is going to be applying to receive a U visa, which is a special immigrant visa for a victim of crime, it may be useful to make a report to police or to have a protection order in place, again, to document that history of violence. All of these cases are very fact-specific, and in just a few moments, I'll talk more generally about whether or not it makes sense to file for a protection order before leaving the original state. An additional question that comes up, just to flag it for you, is the survivor even going to be able to file for a protection order in the new state? And that raises a couple of different legal issues, in particular the issue of personal jurisdiction. And I'll speak to that later during our training this afternoon. The next legal issue on your list talks about the child custody jurisdictional laws. And that is what we're going to spend the bulk of our time this afternoon on. The UCCJEA, in at least 49 of the states, is the child custody jurisdiction law. What that means, and you'll see shortly when we dive into the details, is that for many survivors who are thinking of leaving a state, even if they are able to leave, they get the green light based on the criminal laws, they don't have a problem complying with the state relocation law, there still could be an issue that the left-behind perpetrator is going to fairly immediately file for custody in the state that the survivor is leaving. So in our hypothetical, likely if Lila ends up taking Annie to live with family in California, the left-behind Philip is probably going to talk to an attorney and file for custody within 6 months in the original state of Tennessee. You all have probably seen these cases already in your victim advocacy work, but we tend to see 3 specific types of responses from judges in those cases. One response is the most restrictive. So, for example, a judge in Tennessee has the authority to order Lila to bring Annie back to the state of Tennessee. We do see that happening in some of these interstate cases. A middle ground response by a judge might be to permit someone like Lila to continue living safely in the new state, the refuge state, but to keep the court case, the litigation over child custody, back in the original state of Tennessee. As you can imagine, Even that can be very difficult for a survivor. If someone has fled across the country, it may be difficult for them to come back, to pay for transportation, to have a safe place to stay back in the original state if they have to come back to litigate the custody case. I'm happy to report that increasingly in jurisdictions across the country, some judges are permitting domestic violence survivors to remain in the new state, even if they keep the custody case in the old state, and to testify by telephone. So these possibilities are increasingly happening across the country. The third way that judges may treat these interstate cases is really the most effective for survivors. So if someone like Lila has relocated, let's say to California, and Philip has filed there in Tennessee for custody, as long as Lila is checking the family court in the county that she left in Tennessee, she will know if Philip files for custody. And at that point, she could potentially get in touch with the LRC, and we could try and help her find counsel back in the original state, or perhaps with your help, victim advocacy assistance, she could find an attorney in the original state, and then the argument could be made to the judge in the original state, asking that judge to transfer the entire custody case to the new state. We'll talk more about that procedure later this afternoon, but that is something that particularly folks who are represented by attorneys in the original state are having some success with nowadays. So one of the things that you can do to be helpful to the clients you are going to be encountering is to kind of do a little bit of digging in your jurisdiction to find out how judges are typically handling these interstate cases. That will prepare you to give information to survivors about whether it's more likely that they're going to have to return to the state with their child, or whether they may be able to remain in a refuge state even if the left behind batter files in the home state. The final legal issue that we flagged for you is the state that the survivor is fleeing from going to have something called continuing exclusive jurisdiction? It's a mouthful, but what it means is the original state going to continue to be involved in custody matters over the same child? And that particularly comes up if that original state has already entered a custody order out over the child. So usually, in terms of modifying a custody order from another state, it's not generally available for judges to do that. If Tennessee entered a child custody order over Annie, and then Lila moved somewhere else across the country, the new state, California, is not going to be able to modify that court order out of Tennessee unless some very specific conditions are met. So keep in mind when you're talking with survivors that if somebody gets a custody order in that original state, it may mean that litigation over that child is going to be stuck in that case from now on, particularly if the perpetrator is going to continue to live in that case, to live in that state. Now we're going to take a look at a very specific question that you may receive as victim advocates, and that is, what are the risks and benefits of filing for a protection order before leaving the state with a child? Again, there's no particular right answer for a certain client, but we do want to share with you some of what we have seen as the pros and cons in specific situations. You all are very familiar with protection orders most likely, and probably when there's not an interstate issue, as long as a survivor thinks a protection order would be helpful, it's a great idea to get one. The benefits of obtaining a protection order in an interstate case can be numerous as well. The very first one is, of course, protection orders in many of these cases can actually decrease the physical violence, at least while the protection order is in effect. You all may know that under the Federal Violence Against Women Act, protection orders that are entered by one state have to be enforced all over the country because of the full faith and credit provision. So that means if Lila got a protection order in the state of Tennessee and then later ended up relocating to California, law enforcement and the courts in California would be required to enforce that protection order on Lila's behalf. Additionally, in the kinds of situations, as many of you probably see daily, where perpetrators have threatened to take the children if the survivor leaves the relationship, it can be helpful to have a custody order on the books. So, for example, if there's no custody order in a particular situation, both parents typically have an equal right to have the child with them. So if Lila left Philip and didn't have any custody order in place, and Philip showed up and tried to take Annie from daycare or from the home, the police would not be able to help Lila retrieve the child. That is one particular reason why custody provisions within protection orders can be very useful, and why most of our state protection order laws include temporary custody as one form of relief. Additionally, thinking a little bit strategically in a case like Lila's, there has not been a lot of documentation of the violence in the past. So getting a protection order before leaving the state of Tennessee, because Lila is certainly eligible for one based on the violence that's been perpetrated against her, getting that protection order can provide some documentation of the violence. And why might we want documentation of that violence in the future? As many of you know, probably custody is going to be fiercely litigated. In virtually all of our states, the custody statutes say something about domestic violence. They may say that domestic violence is one factor in a laundry list of factors that a judge has to consider when making a custody determination. Or in some states, they may even say that where there's been a history of domestic violence, there's a rebuttable presumption against granting custody to the perpetrator of the violence. But all of these cases come down to judges who are looking for evidence of that history of violence. So again, that may be one good reason to get a protection order before leaving the state of Tennessee in Lila's case. Additionally, you'll hear later during our time together today about some jurisdictional arguments that also turn on whether or not there's been a history of domestic violence. So for example, I'll be talking with you about a new refuge state and how they are able to exercise something called emergency jurisdiction. I will also be sharing with you a legal argument called inconvenient forum, which is a type of argument that can be made to the home state. Both of those jurisdictional arguments turn on whether or not there's been a history of domestic violence, and as you all see in your day-to-day work with survivors, judges are frequently looking for more evidence beyond the testimony of the survivor. So getting a protection order can help with that as well. And finally, our last point in terms of the benefits of getting a protection order before leaving the state include that the survivor may be unable legally to get a protection order in the new state that she's fleeing to. And we'll talk about that in a few minutes. On the other hand, there also are some risks of getting a protection order in an interstate case before leaving the original state. And the biggest risk may be that frequently, if a survivor is awarded custody as part of a protection order, then the perpetrator often may get some type of visitation written into that protection order. And if the visitation is somewhat typical, and it says something like alternate weekends and Wednesday evenings, visitation to the perpetrator, that may make it impossible for the survivor to leave the state. Or someone like Lila would be leaving the state while violating a court order, which is not anything we can recommend. Additionally, there are other laws that are triggered by the existence of a custody provision, even if that custody provision is entered as part of the protection order. So, for example, I mentioned this idea of continuing jurisdiction a few minutes ago. Even a custody provision within a protection order is enough to give a home state continuing exclusive jurisdiction over the custody matter. What that means is that if someone like Lila thinks that Philip is not going to file back in Tennessee if she leaves and goes to California, then it would kind of be hurting herself to file for a protection order before leaving and to get custody as part of that protection order, because that would be one more thing, continuing jurisdiction in Tennessee, that would kind of trap her in the state of Tennessee, at least for purposes of litigating the custody case. Similarly, in many of your states, your state parental kidnapping laws or your state relocation laws may not typically come into play in a situation like Lila's, but the minute a custody order has been entered about Annie, that may trigger your state parental kidnapping law and your state relocation law. So again, consulting with an attorney in your own state to find out about your state-specific laws is extremely important. But just know that getting a protection order in these interstate cases, it can be beneficial in some cases, but it also can be a hindrance in other cases. The last point on our slide about the risks of getting a protection order in an interstate case has to do with a jurisdictional argument. So again, I'm going to talk about that later this afternoon, but an inconvenient forum argument is the argument that is made to the court in the home state, asking that court to transfer the custody case to a refuge state. One of the factors that a judge has to look at if somebody broaches that idea is there any court that already has familiarity with the parties and the subject matter here? So getting a protection order in the state of Tennessee, in Lila's case, is actually going to give Tennessee more of an investment in this family. And it may mean that down the road, if Lila asks a Tennessee judge to transfer the case to California, there's at least one factor that's going to weigh in favor of Tennessee keeping the long-term custody case. So as you can see, there's no particular answer for all of these cases, but there are many benefits and risks to getting a protection order before leaving the state. We're happy to talk with you if you have a particular case that involves this issue. And now Jenny's going to talk with you about some of the safety and economic issues that frequently come up in these interstate cases.
Thank you. And so there are many, many issues to consider as a survivor is thinking about relocation. Questions to think about and confer with your survivors you're working with are, is the refuge state safer? And what is the survivor's relationship to the refuge state? Does the survivor have support structures in place for emotional support and for getting their basic needs met? And do they need help being connected to those resources? Do they know how they're getting to the refuge state? Is the car in the survivor's name or in the abuser's name? And what should the survivor bring with them? We think that important documents such as prescriptions, identification cards, birth certificates, Social Security cards, immigration paperwork, if they have it, are all important to bring as well. And some tech safety considerations. Something I talk about with survivors are they on the same phone plan with their abusive partner? Does the abuser have access to any of the survivor's email or bank accounts? Have they ever shared devices that save passwords? All of these are ways in which we can have conversations with survivors to develop and increase their safety. And will the survivor be able to access legal assistance in the new state? And does she know what those are? We know that survivors know their situations best and are often forced to make these very difficult decisions while navigating the daily reality of living with trauma and abuse. We want to assist survivors in setting them up for success wherever they will go while not undermining their autonomy and decision-making. And since there are so many decisions to weigh, it can be helpful to have the survivor work with an advocate in the refuge state and in the home state to help address safety and economic issues that are going to come up for domestic violence survivors and their children trying to flee.
Thank you, Jenny. So now I'm going to dive into the federal and state laws that often come into play in these cases. And when we do our in-person trainings, you can see a range of rainbow flags across the room that are highlighting just how many different laws are involved in these interstate issues. So I'm going to start with the federal laws. As many of you know, the Violence Against Women Act was a federal law that was enacted in 1994 and then reauthorized in 2000, 2005, 2013, and now is pending for reauthorization as well. This particular act has funded many of you to have victim advocacy positions in communities across the country. And in addition to funding many grant programs and creating some federal crimes, there is the provision I mentioned briefly earlier. That is the full faith and credit provision of the Violence Against Women Act, which essentially says that states need to honor and enforce protection orders that are entered by sister states. That's why we mention that here, because that includes child custody provisions within protection orders, and it includes it very specifically after some of the reauthorizations of the Violence Against Women Act. The next acronym you may hear in these sorts of interstate cases is the PKPA, or the Parental Kidnapping Prevention Act. Although the name of the law suggests that it's a federal criminal act, it actually is not. The PKPA basically says that states have to honor and enforce custody orders that were entered by sister states. So, for example, in Lila's situation, if she did get a custody order in Tennessee and then moved with Annie to the state of California, California would have to enforce that Tennessee custody order. You can't just start over in a new state. The next federal law is the Indian Child Welfare Act. It had somewhat a different genesis, and that is in 1978, Congress passed it in response to the frequent removal of Indian children from their families. ICWA was really designed to prevent the unwarranted removal of Indian children and to establish some minimum federal standards for that to happen. It also gave Indian tribes exclusive jurisdiction in these specifically defined types of child custody proceedings. So child custody proceedings under ICWA include cases where the state is involved, typically termination of parental rights cases, pre- and post-adoptive placement, and that type of thing. ICWA does not apply to the types of cases we're talking about generally in our training this afternoon, to either protection order cases between two biological parents or to custody cases between two parents. However, I mention it here because the UCCJEA, the uniform law we're about to examine, says that when ICWA is involved, ICWA governs. So the first question for attorneys is this an ICWA case? If so, then that is the federal law that applies. The next federal law I want to mention briefly is the International Parental Kidnapping Crime Act. And I mention that because I know that many of you talk to survivors who flee not only between states and between state and tribal jurisdictions, but you also talk to survivors who may be thinking about fleeing internationally back to their home country or fleeing from another country to the U.S. In the United States, if someone flees from the U.S. to another country, there is a federal parental kidnapping crime that someone could be charged with. And there also is a very specific defense. It's called an affirmative defense based on fleeing from an incident or pattern of domestic violence. And we've given you the site there. Now I'm going to turn to the state laws, some of which we've mentioned previously, but I just want you to know how many different laws are involved in these sorts of cases. So again, we're going to talk momentarily about the UCCJEA. You all are very familiar, most likely, with the custody laws in your own jurisdiction. Those are the underlying substantive custody laws that set out what is in the best interest of the child and what factors judges have to weigh when they're making that type of decision. There are also tribal custody laws, and because every tribe is a sovereign nation, each tribe has its own tribal code. So they may have custody laws that differ, and they also may have child custody jurisdictional laws that differ. The UCCJEA, by and large, has not been adopted by Indian tribes, but each tribe will have its own child custody jurisdiction law. Additionally, the next type of law listed on your slide is what's called a state full faith and credit law. It's similar to the federal full faith and credit provision, but it applies only to a specific state. And typically, it sets out a court management or an enforcement mechanism for how exactly the new state should be enforcing a protection order out from another state. speaking of protection orders, you're all quite familiar with protection orders within your own state. I also want to mention that tribal codes may have certain eligibility requirements for protection orders as well. And many of you work with military families, so you may be encountering a type of case where a survivor has been issued a military protection order because of what's gone on. We are going to talk about state relocation laws and parental kidnapping laws a little bit later this afternoon. But for now, if you think about the laws on this slide and the former slide, what becomes very clear is that any survivor who's contemplating relocation from one state to another should be talking with a very experienced attorney before leaving. We know that that's the ideal and it's not always possible, but we want you as advocates to know that one of our roles here is to try and help find consultations for survivors who may be thinking of leaving a state. So if you've got a client in that situation and you don't know any attorneys in your area, please feel free to call us or to have your client call us directly, and we can make those arrangements. So now we're going to turn to the UCCJEA, the Uniform Child Custody Jurisdiction and Enforcement Act. For those of you who aren't as familiar with uniform laws, these are laws that are developed by the Uniform Law Commission, and then they're kind of shopped around, and individual states are asked to adopt the law or a version of the law. With respect to the UCCJEA, at this point in time, 49 states and the District of Columbia, as well as Guam and the Virgin Islands, all have enacted the UCCJEA. So Massachusetts has not, nor has Puerto Rico. The UCCJEA provides some significant improvements for survivors in a couple of different ways. The drafters, thanks to advocacy from those in the battered women's movement at the time, recognized that many of these interstate cases involving families had an underlying issue of domestic violence, and that was prompting much of the parental abduction, perhaps by perpetrators, and much of the fleeing for safety on the part of the survivors. So within the UCCJEA, there are now legal protections based on domestic violence, and we'll be talking about two of the major ones, emergency jurisdiction and an inconvenient form argument, as we move along today. But I do want to mention one thing to those of you advocates on the line, and we may have a couple of attorneys on the line as well, and that is you can see a copy of every state UCCJEA on our website. The address is listed on the last slide. And you also can see a copy of the Uniform Code itself. So the Uniform Code not only has the language that all the states then went and adopted, but it also has the reasons behind each of those provisions. And that is called commentary. So for example, if an attorney on the line happens to be working on an emergency jurisdiction argument, looking at the Uniform Code and the commentary to Section 204, which is on emergency jurisdiction, can provide some language for making arguments in a brief or for oral argument about this idea of emergency jurisdiction. We find that attorneys have been fairly successful in using that commentary that's part of the code. I do want to mention to you why it was necessary in 1997 to develop the UCCJEA, and that's because the older version of the law, which is missing the E, it was just called the UCCJA, the older version of the law still led to a fair amount of confusion. And that was because under the old version of the law, several states could be involved in the same child custody matter properly under the UCCJA. So there could, for example, be one home state that was getting involved, another state that had a significant connection, and judges in those two states might have properly been exercising jurisdiction and yet ending up with opposite results in a child custody order. Under the UCCJEA, that will not happen, and that is because there's a particular hierarchy that is established under the UCCJEA. So we're going to examine that in just a moment. This particular slide shows you some questions that you might have or your clients might have in these sorts of cases. So for example, Lila might wonder, can she get a custody order in Tennessee? She might wonder, can she get a custody order in California if she leaves Tennessee with Annie? She might wonder if she might be charged with parental kidnapping, a crime, or if it's even legal to leave the state of Tennessee. And she might also worry about what's going to happen if she's forced to return to Tennessee. So we're going to take these questions one at a time, knowing that you may get them on a daily basis. But of course, having connections with attorneys in your jurisdiction so that you can refer survivors to those attorneys for direct legal advice is critical. So number one, can Lila get a custody order in Tennessee? That depends on whether or not Tennessee has the authority to get involved in this custody matter. And here we're going to show you this jurisdictional hierarchy or ladder that sets out the 4 different jurisdictional bases under the UCC-JEA. You may have heard of some of these in the past, or this may be brand new. What I want to point out on this slide is that the home state has priority under the UCC-JEA, and that was the biggest change with this new uniform law. That means that where there is a home state, that is the place that gets to be involved in a custody matter over those children. And we'll talk about the definition of home state in a moment. It's only if there is no home state that you move to the next rung of the ladder and examine whether or not there's a state that has a significant connection to the family. The third rung of the ladder, more appropriate forum, we'll talk about later this afternoon, and that has to do with the state that has preferred jurisdiction, typically the home state, giving it up in favor of a more appropriate forum. We'll talk about that momentarily. Finally, the bottom rung of the ladder doesn't come up very often, but if no other state could possibly get involved in this child's custody order, then any state can exercise jurisdiction. It's sometimes known as vacuum jurisdiction or jurisdiction of last resort. That doesn't typically happen, but for example, in a case where the family moved quite frequently between states, maybe 2 weeks in one state, 3 weeks in another state, 5 weeks in a third state, that might be a situation where a court could exercise no other state or vacuum jurisdiction. So now we're going to talk about the home state rule, one that may be most familiar to you all, and certainly is most familiar to judges in these cases. Sometimes it's known as the 6-month rule, and what it means is that the state where the child lived with a parent or a person acting as a parent for 6 straight months before the commencement of a custody proceeding, that is the home state, and that state has priority. So again, to put it simply, in a situation like Lila's, where Annie has lived her whole life in Tennessee, she's lived there for more than 6 months, Tennessee is going to be Annie's home state. I want to draw your attention to the language that says the commencement of a child custody proceeding. That's defined under the UCC-JEA as the day when the first parent files for custody. So it doesn't mean when the other parent gets served with the paperwork. It doesn't mean the first day that a court starts hearing issues about the family. It means the day that the first parent files. And that's important because in so many of these interstate cases, it may be a situation where the left behind parent like Philip talks to an attorney after the survivor leaves with the children, learns about the 6-month rule, and in fact learns about something called the extended home state rule. What that means is there's an extra 6-month window after the child is removed from the state, during which time that original state still maintains jurisdiction over the custody matter. So if Lila were to take Annie today and go to California, Philip would have an additional 6-month window during which time he can file for custody in Tennessee. And the custody case doesn't have to be resolved. Just the very first pleadings have to be filed in Tennessee. If Philip did that 5.5 months after Annie had been removed to California, Tennessee would still have jurisdiction. We encounter many of these situations with survivors who call the LRC, and that quite frequently is why we are looking for representation for survivors back in the home state, because the survivor has moved, has fled the violence, but the left-behind perpetrator has filed in the home state and filed properly within that 6-month window. I want to mention a couple of other nuances to the home state rule. Sometimes very small infants are involved in this rule, and if the child is less than 6 months old, the home state is defined as the state where the child lives from birth. So that sounds simple, but what if it's a situation where the child is born in a hospital, as in our geographic areas frequently happens, the child's born in D.C., but then after a couple days or a couple weeks moves out to Maryland or Virginia. So if you have a case involving a child who's less than 6 months old, feel free to contact us at the LRC. I see a question on our chat from Aaron asking, can we speak to how this impacts a situation where a child is not yet born? And I'm glad you raised that question, Aaron. The UCCJEA does not apply until a child is born. So if a woman is pregnant and doesn't have any other children, she is free to travel wherever she wants, free to move. We have seen one state that had a bit of, I think it was only one case, going the other direction, but that was overruled. So at this point in time, it's my understanding that a pregnant person can move across state lines, again, assuming there's not older children involved, and that would absolutely be the time for someone to move, because it's going to get a lot harder after the child is born. All of these legal issues come into play. I also want to mention the idea of temporary absence, and that is sometimes families or children leave a state and go somewhere for a short amount of time. So maybe baby Annie had a 2-week visit with some maternal grandparents in the state of California. A temporary absence from the home state is not going to deprive the home state of the ability to get involved in a child custody matter, and it's not going to deprive the home state of its priority. Where it gets complicated is there's not a specific definition for how long a temporary absence can last. So, for example, in some cases, judges may decide that even being away for a year is a temporary absence, while in other states they might look at it differently. Typically, they look at things like, what were the intentions of the parties when they moved? Did they intend to permanently relocate and then change their minds? This comes up very frequently, again, in cases with military families. So the military member of the family may be deployed, and the children and the spouse may go with the military member. Is that a temporary absence from a state that is then the home state? Again, we've got some case law on all of these issues. Feel free to call us if you or an attorney you're working with in your neighborhood has that type of case. And finally, what I want to mention very particularly for advocates helping survivors in these cases is that extended home rule can be so difficult for survivors. And we know that the survivors we talk to quite often just want to get away from the violence and go to a safe place somewhere else. They don't want to think about what's going on back in the state where the abuse has been perpetrated against them for obvious reasons. It is so important, though, for survivors to be calling and checking in with the family court back in the original state just to make sure that a custody case has not been filed. So, for example, a perpetrator may misinform the survivor and say that there has been a custody case filed when there really hasn't, or quite often the opposite happens. A perpetrator may not tell the survivor that the perpetrator has filed for custody in the original home state. And it may be that the perpetrator either doesn't know where the survivor is or is deliberately not serving her with the paperwork, but eventually the court in the home state is likely to allow that custody case to go forward. If someone hasn't been served and one of the other party can show that they've made efforts to serve the person or asserts that they just don't know where the other person is, a judge is going to permit that custody case to go forward. And I'm sure as advocates you all can imagine the fact pattern that the judge may be hearing from the left behind perpetrator is going to be very different. So the judge may actually grant an order of custody to the left-behind perpetrator if the survivor is not involved. That's why we so strongly recommend that the survivor, or perhaps an advocate working with her, check in with the family court in the county that she's left about once a week for the next 6 months after leaving. And if something has been filed, it's best to know about it at an early stage. I know that sometimes people think evading service can be effective, but we really have not seen that and would never recommend that in these interstate cases. So you can help out by letting survivors know if they're going to relocate to please check in with the courts back in the original state. So now, just briefly, I'm going to talk about some other jurisdictional bases. As I mentioned a few moments ago, Tennessee is the home state for Lila. And so in Lila's situation, we would not even examine this other rung of the ladder, the significant connection rung. But you may have cases where the family hasn't lived somewhere, the child hasn't lived somewhere for a full 6 months. Let's say a child lived in one state for 5 months and then another state for 3 months. In that situation, there would be no home state. And where there is no home state, then the courts can look to the second jurisdictional basis called significant connection. What significant connection means is that the court and that jurisdiction has enough contacts with the child and the family, and there's substantial evidence about the child's care, protection, and personal relationships that it's fair for a judge in that state to hear the custody case. This is the only time under the UCC-JEA where it actually matters who files in the courthouse first. So typically, if there's a home state and the child's lived somewhere for 6 months, it really doesn't matter who files first because there's only one home state, and that is going to have priority over the custody case. But if there is no home state and we're thinking about significant connection states, there could actually be more than one significant connection state. As I mentioned before, maybe the family has lived for 5 months in one state and 3 months in another state. And then it really matters who files first, because if a parent files in one of those significant connection states and the second parent then tries to file in a different state, the second state, the judge in that state, is going to have to put the brakes on the custody matter. They cannot move forward with it if there's something already pending in a state that has a significant connection. So if you have any cases where you think those fact patterns might be at play, again, please feel free to refer the survivor to us, and we'll try to help that person to find representation in the state where it's needed. And so now Jenny is going to talk about what advocates can do to help, but I'm seeing another question, which I'll just answer right now for you, Ginger. You asked if a judge would let the case go forward when the perpetrator files for custody, even if there's a protection order against the perpetrator. And sadly, that can be very disconnected from the custody case itself. There are some jurisdictions across the country that are starting to merge the various family law and domestic violence proceedings. So there's a handful where the judge may know about the existence of a protection order and might start asking questions. But in many parts of the country, a judge in a custody case isn't even going to know if there's a pre-existing protection order that was entered against a certain person. Let's say it's a situation even where the judge does know about the entry of a protection order, still there are laws around alternative service and notice by publication, meaning that if the perpetrator is saying, I don't know where she went, she kidnapped the kids, I have no way of getting in touch with her, and demonstrates that the perpetrator's counsel shows that they've tried to serve her in certain places, probably the judge is going to let that custody case go forward, unfortunately. Yes, so now Jenny is going to talk about what advocates can do to help.
Hi, thank you so much. And so something that advocates can do to help, which we've talked about and we'll just continue to stress, is advocates can help Lila find an attorney to represent her in Nashville. You can find out if local programs receive VAWA funds to represent survivors to help narrow down your search. And also, we recommend forming relationships in advance with local legal service providers and law firm pro bono programs. In many cases, survivors will qualify for civil legal services at these legal aid organizations, and some agencies will not take into account the abuser's income, and some may even waive any financial requirements for survivors. If the survivor is conflicted out from in-house legal services, they may be eligible for private attorney involvement or the volunteer attorney program if your legal service organization has these programs. And these are programs where private attorneys take cases that are referred by the local legal aid organization. If the survivor is conflicted or doesn't qualify for these services, you can also contact the agency to see if they are able to provide you with a list of their volunteer attorneys. You can then contact these attorneys to see if they are willing to take pro bono cases with direct referrals from your organization. If you're working with a survivor who has fled to your state, your local legal services organization may be able to send a referral in the home state. Additionally, some legal service agencies may say that they will not take cases for those who are not currently living in the state. And in those instances, it can be helpful to stress that a matter is venued in a particular county, the severity of the abuse, and if something has been filed by the abuser or if there is a pending court date. As I said, it can be helpful to keep track of solo practitioners who may be willing to represent survivors on a sliding scale basis. And it can also be helpful for advocates to share information with State Domestic Violence Coalition and local domestic violence programs regarding sympathetic attorneys. If you're speaking with somebody who was charged with violating a parental kidnapping statute, you will want to see that she gets connected with a defense attorney or public defender. Another resource we recommend is our sister organization, the National Clearinghouse for the Defense of Battered Women, and they work with domestic violence survivors who are charged with crimes, including parental kidnapping, and they can speak with survivors directly or provide technical assistance to their attorneys. And so what else can we do to help? We can help Lila document the abuse, since some legal protections are available if there is a history of domestic violence. You can connect the survivor's attorney with the LRC if the attorney is unfamiliar with using jurisdictional laws to assist survivors of domestic violence. And you can also help Lila develop a safety plan and think about how she might be able to access resources to meet her immediate needs as well.
Thank you. Okay, so now we're going to turn to another state and see if Lila can get a custody order if she flees to the refuge state of California. So this particular issue is what raises the idea of California exercising emergency jurisdiction. Emergency jurisdiction under the JEA, you can see the language on your slide, is something that a court can do where necessary in an emergency to protect the child because the child or a sibling or parent of the child is subjected to or threatened with mistreatment or abuse. The one requirement for a court to exercise emergency jurisdiction is that the child has to be present in that state. So for example, if Lila fled from Tennessee to California and didn't take Annie with her, which we would never recommend, she would not be able to file for emergency custody in California. But as long as the child is there, the refuge state can decide whether or not to enter an emergency order. Now, this may be news to some of you on the phone, not just advocates, but many court clerks, many judges, many attorneys are very familiar with that 6-month rule, but are not familiar with this exception for emergency jurisdiction that says you do not need to wait a full 6 months in the refuge state to file for emergency custody. We hear from a lot of survivors who have tried this in the refuge state when they get there and have been turned away at the courthouse door because folks just are not familiar with this provision within the UCC JEA. So feel free to share this information with colleagues and folks on a local coordinated community response team because it really can be helpful to survivors. Now, we don't automatically recommend that a survivor who comes to a new refuge state just immediately file for emergency custody, but to consult with an attorney and then to make that decision. sometimes filing for emergency custody in the new state, if the perpetrator was not going to file back in the home state, it can trigger the perpetrator to do something in the home state, and that can make it more difficult for a survivor. On the other hand, if the survivor's in the new state, and let's say it's Lila and Philip again, and Lila's worried that Philip is going to show up at her sister's house in California and take Annie, then it may be very important to have an emergency custody order in effect so that Lila can make sure she's able to ask law enforcement to help her to get Annie returned if that should happen. So emergency custody is a possibility in these cases. The language that's underlined in the statute shows you what new language is in the UCCJEA that was not in the original UCCJA. So that language about abuse against a sibling or parent of the child is new. And what it means in practice is that even if the child himself or herself has not been physically abused, if the parent of the child, in our case Lila, has been abused, that is enough for a judge to get involved in the refuge state and to enter an emergency order. Okay, so I want to also mention that emergency jurisdiction under the UCCJEA is only temporary. There's not a particular time frame. They thought about it, the drafters, when they developed the UCCJEA, but ended up not putting a particular time frame into the law. So that means that your judges in your state are going to be basing it on case law in your state and what they think makes sense in a particular situation. And so there's no exact answer for how long an emergency order can last, but the way that it gets resolved is that if, let's say, Lila moved to California and got emergency custody, and then Philip filed back in Tennessee within that 6-month period for long-term custody, then there's a requirement that the judges in the two states communicate with each other in order to resolve the emergency, protect the safety of the parties and the child, and to figure out how long that emergency order should last. So just to be clear, someone like Lila may be able to go to a new state, get a protection order, including temporary custody in that new state, and there doesn't have to be judicial communication before that. But once there's something pending in two states, no matter what the circumstances are, if there are courts in two different states involved with the same child or the same family, those judges are mandated to communicate with each other. Just to give you a little bit of sense of the judicial communication, the parties don't have to be present, but they do have to have an opportunity to be heard on the facts and the legal argument. So in some states, the way that looks is that an attorney can submit a motion before the judge, a written motion. Sometimes attorneys have an opportunity to appear for an oral argument, and sometimes there's a full-blown evidentiary hearing with the judges on the phone from both states, the parties in both states, and attorneys in both states. It really varies, that particular practice around judicial communication. So now I'm going to talk more specifically about what if Lila wants to get a protection order in California. What we just talked about was how Lila absolutely can apply for emergency custody in the refuge state. But what is less certain in all of these cases is whether or not someone like Lila could get a protection order in the new state. And that's because protection orders often involve a few additional legal issues. One of them is what's called personal jurisdiction. So generally, for a court to be involved in a particular case, the judge has to have the authority over the subject matter. With our cases, we're talking about child custody. But also, judges have to have authority over the people involved. And in a protection order proceeding, what that means is that the court has to have personal jurisdiction with the respondent, Philip. Meaning that if Philip has never spent any time in California, has never set foot in the state, has never called and threatened Lila in California, hasn't been there for a visit or a stopover in an airport, if there are not minimum contacts between Philip and the state of California, that is probably going to mean that a protection order judge cannot enter a protection order out over Philip. Now, I want to say there are a couple of states that are handling personal jurisdiction a little bit differently in protection orders, but the vast majority of your states, your judges need to have personal jurisdiction over the perpetrator, meaning that the perpetrator has to have had minimum contacts with that new refuge state. So if this comes up in your particular practice, you can try ahead of time to talk with attorneys in your area about what your state personal jurisdiction law says. You can also ask your client about every contact that the abuser has had with your state. So things like business and travel, perhaps stalking in the new state, as well as telephone calls or the use of social media are things that are starting to come up in the case law. And please feel free to call us or have attorneys call us for some of this case law around personal jurisdiction. All right, so I see we may have had a couple of questions. Somebody has answered the name of the National Clearinghouse for the Defense of Battered Women. And I see we also have a question from Beth Levy that if the children have lived for less than 6 months in one state and the abuser was arrested for violence, can she just leave and go to another state? Unfortunately, it's not quite that simple. What it's going to depend on is what does the parental kidnapping law say in that state, so making sure that she's not going to be inadvertently violating a criminal law herself. And number two, to make sure that it's not a state where the relocation law applies. And Beth, I don't recall what state you're in, but for example, Pennsylvania has a very difficult state relocation law, and it's been deemed to apply even in situations where there's never been a custody order entered. So that a survivor who wants to leave Pennsylvania under the letter of the law should be making a relocation argument to the judge in Pennsylvania before leaving the state, even if no one has ever filed for custody previously. Okay? All right, so we are going to move along, and Jenny is going to talk about what advocates can do once more.
Excellent, thank you. And so what can advocates do? We can connect the survivor with an attorney. We can have pre-existing relationships with local legal services or attorneys to ensure that survivors aren't rejected for services due to that 6-month misnomer when attempting to file for emergency custody. We can assist survivors with documenting the domestic violence evidence gathering. Your slide here provides a list of useful evidence to establish previous domestic violence, some of which are the same sorts of records advocates would urge a survivor to take along if she is fleeing across state lines, such as medical records or school records for the children. Oftentimes, survivors will email pictures of property destruction or injuries or screenshots of messages, etc., to a friend or a family member for safekeeping, or to an email account or a Dropbox that's unknown to the abuser. And so these are all things that we can be talking about with domestic violence survivors as they're trying to navigate and make these really difficult decisions. We can hopefully help to fill in some of the holes.
Thank you. And I can see that you all are excellent advocates on behalf of the folks you're speaking with because you have some great questions here. So on the question about how personal jurisdiction applies to someone who is undocumented, it's going to be the same situation with respect to if a survivor is trying to get a protection order in a new state against a respondent. His or her minimum contacts in the new state are going to be what determines if that protection order judge has personal jurisdiction, so unrelated to immigration status. And I also see a question about whether or not there are states in which someone can file for custody prior to the birth of a child. I'm not aware of any. I would defer to Amanda with the National with NCJ-FCJ, who's doing some legislative research. I have never seen that in a state previously, but you never know what could be happening with state legislatures, but typically not. And you also have asked a question about how you can document if the abuse is not physical. The UCCJEA doesn't really define domestic violence or abuse, and in fact, the the discussion, the limited language in the emergency jurisdiction provision is a little bit broader than physical violence. So it does talk about mistreatment or abuse. So I would say the same ways in which you prepare for a protection order hearing, helping to get things like 911 calls, maybe emails or messages that are threatening, pictures of damaged property, obviously pictures of things like bruises or medical records if that has been the case. All of those types of documentation that you would use for a protection order proceeding can also be relevant in an emergency jurisdiction proceeding. You have asked if these protections around emergency jurisdiction apply to survivors who are not being physically abused. And again, the case law, we would have to take a look at that. Typically, there is some physical abuse or at a minimum some type of mistreatment. I've certainly seen cases where someone's been deprived of medical care or food or that type of thing. So you can feel free to contact us if you'd like to take a look at some of the case law. I'm going to move on to the issue of inconvenient forum and unclean hands because this is the only way in which the new state could get involved long-term in the custody matter. And today we're not going to talk much about unclean hands, but just to give you a taste of it, that means that's more a situation where a perpetrator takes the children to new state, maybe unilaterally hides the children from the other parent, and then at that point later, after 6 months, tries to get the new state to exercise jurisdiction. The new state should not do so if the perpetrator has what's called unclean hands. Feel free to call us if you have questions about that. But for now, I would like to talk with you about the inconvenient forum argument under the UCC JEA. For you advocates on the line, you may be learning about something that your fellow attorneys in your jurisdictions maybe haven't heard of before. And that is the idea that you can ask a court that is the home state or for some other reason has preferred jurisdiction to decline jurisdiction in favor of another forum. And there's a recipe or a roadmap within the UCC JEA that tells a judge 8 different factors to look at. The very first factor is whether or not domestic violence has occurred and which state can best protect the parties and the child. So in these cases, again, you see why it's important to have documentation of the domestic violence that can be very helpful in making an inconvenient forum argument. In a situation like Lila's, that inconvenient forum, and any situation, the inconvenient forum argument has to be made to the home state. So in Lila's case, that would mean getting an attorney back in Tennessee, having the attorney make a motion for inconvenient forum. Some other factors that apply also are relevant in many of your cases. One of them is the relative finances of the parties. As you know, financial abuse is so often present in these cases that quite typically the domestic violence survivor, even if that person had a job, has left the job to move to a new state, and probably is going to be, there's going to be some kind of income discrepancy, meaning that the state should decline jurisdiction in favor of the state that the survivor has gone to. Now, there also are other factors involved, and the older the children are, the more evidence that's in the home state, the more court hearings that have happened previously about this family, the less likely it is that a judge is going to transfer a custody case to a new state. So feel free to contact us, again, if you need case law around that particular issue. And just going back and forth again to these active questions in the chat, this one is from Tanya Lopez, who asked, would a victim only need one protection order, or would she try to get a protection order in both Tennessee and California? And as I mentioned before, you really don't need to have more than one protection order now because of the Federal Violence Against Women Act. So if Lila had a protection order in Tennessee, she wouldn't need to get a new one in California. California should enforce her Tennessee order. But sometimes, because of the issues we talked about, survivors may not want to get a protection order in the original state before leaving, or it may be not the greatest idea in terms of strategy to do that. So that's why we were also talking about whether or not a survivor would be eligible for a protection order in that new state. All right, so now we're going to turn to Jenny again to talk about what advocates can do with this inconvenient forum issue.
Yes, so if Lila does not have an attorney in Tennessee, advocates can help her find out if Philip has already filed for custody after she left. So you or Lila can do this, as Deborah mentioned earlier, by calling the family court in the county that the survivor left behind to see if the left behind parent has filed for custody in that county. You can also help Lila find out if she can participate by telephone on these hearings in Tennessee. We're seeing increasingly that judges are allowing survivors to participate this way. You can also help Lila find an attorney in the home state and in the refuge state. Advocates can assist Lila to provide the attorneys with evidence of domestic violence to help strengthen the inconvenient forum argument. And as always, you can always refer to us as well to help in situations like this.
Thank you. So our next question is, what if Lila is required to return to Tennessee to litigate the custody case after having relocated safely to California? And this is just a reminder that in some of these cases, judges are going to either require the children to be brought back to the original state or require the survivor to return to the original state for purposes of participating in that child custody case. And we always would recommend that survivors participate either by telephone, if that's permitted, or in person if need be, because that information that the survivor can share with the judge is going to be critical to getting a custody order that is fair and safe for the children. So again, I'm going to turn to Jenny just briefly to talk about what advocates can do.
Right, and so if this is what's going on, we can try to help Lila find an attorney in Tennessee. You can also connect the attorney with the LRC if needed as well. Advocates can also help Lila plan for her safety on the court dates that she has to return to Tennessee. Does Lila have a safe place to stay while she's in Tennessee? Will she need to go into confidential shelter? Tennessee advocates could also help gather relevant evidence from Tennessee. For example, oftentimes domestic violence survivors have difficult times getting police reports and other documentation after they've left the home state. And so local advocates on the ground might be able to help gather some of that evidence to get some of that legwork out of the way for Lila. California advocates can help Lila gather relevant evidence from California. And we've had many instances where two advocates in different states are working together for the survivor, and we find that is always good practice to have more than one person working on behalf of the survivor.
Thank you. So in just a moment, I'm going to address the issue of whether it's even legal for Lila to leave the state with her children. But I see that we have a question from Michelle Robinson, who's asking, what happens if a parent is asked to leave the home due to abuse and the child remains with the abuser? Can the parent who's not living in the home pick the child up at any time they want? If there's not a custody order in place, would they have to address it from a legal process at that point? And I first want to say I don't practice in every state across the country, so please don't take this as direct legal advice if you have a client you're working with in this exact situation. We're more than happy to try and connect your client to an attorney in your jurisdiction for direct legal advice. But in terms of a more general question, in virtually every state across the country, in the absence of a court order regarding custody, typically both parents have an equal right to have the child with them. Now, there are a handful of states that still have laws that, let's say, if the father is not listed on a birth certificate and it's an unmarried couple, they may have an automatic presumption that custody goes to the mother. There are very few states left like that, but a handful in the Midwest. But barring that, both parents are going to have the equal right to have the child with them. You're really asking a question around self-help, and one of the things that occurs to me is that it could be dangerous if there's been physical violence and a severe episode of violence, just kind of showing up to take the children from a perpetrator. That could be something that could involve a safety risk for sure. So I would think about that. But in terms of the legal issues, typically when there's no court order in place, both parents do have a legal right to have the child with them. I would say from a longer-term standpoint, it's always good to try and get a custody order on the books, especially if it's not an interstate case where someone's going to want to leave the state after, because you want to have this resolved and you want it to be as clear as possible for law enforcement should they need to be involved. Okay, so now in our remaining time, we're going to talk about two legal issues. The first is state relocation laws. So state relocation laws historically set out the standards that have to be met prior to relocating with children. Generally, in most of your states, they cover what a custodial parent should do, meaning a parent who already has a custody order. What steps that parent would need to take in order to relocate with the children out of state. Sometimes state relocation laws apply only to out-of-state relocation. Sometimes they cover relocation even from county to county within a state. And still other times there might be a particular geographic distance. For example, if you move more than 150 miles away from your current address, then you have to comply with the state relocation law. So this is quite variable by state, and please check in with attorneys within your state. We do have some relocation laws on our website, but we really view that as a starting point for your research, particularly because many state relocation laws are found not just in a very clear statute in your code, but they may be elsewhere. So, for example, they could either have a nicely labeled state relocation law in your code, or there might be one provision within your child custody law itself that generally talks about the best interests of the child. There may be one provision that talks about relocation. Or there might not be any language like that in your state code, but there might be standards that have been established by judges in case law. So for that reason, you should make friends with attorneys in your neighborhood and make sure those attorneys are well-versed in your state relocation law. Next, we often get this question, and as I already mentioned, it really depends on the state. Still, in the majority of states, these relocation laws apply after the entry of a custody order. But as I gave the example before with Pennsylvania, there are states that are starting to have stricter relocation laws that even apply before the entry of a custody order, or sometimes even before someone has filed for custody. So please familiarize yourselves with the laws in your state, and then do not give direct legal advice to survivors, but use that information to inform your advocacy with them. Again, what do relocation laws require? It varies by state. In many states, you have to notify the other parent before moving. Sometimes you have to contact the judge and ask for permission to move. Many of these relocation laws have a list of factors that a judge has to consider, and sometimes in that list of factors is a domestic violence factor. In terms of the burden of proof, that also varies by state. So in some states, the relocating parent has the burden of showing that the move is in the child's best interest, or in some states, the standard is that they have to demonstrate there's an exceptional circumstance. In other states, the burden is on the non-custodial parent to show why the move would not be in the child's best interest. So here are some things to look at when you investigate your state relocation law, and that is, when is it triggered? Is it only after a custody order has been entered, or at any time? What are the steps that a parent needs to take? What if the parent doesn't comply? Does that mean that the judge is going to be able to switch custody to the other parent? Is domestic violence even a factor? And of course, what is my role as an advocate? In terms of what these laws mean for survivors, as you can imagine, it can be very difficult to get permission to relocate without being represented by counsel. For example, in Pennsylvania, there are 26 different factors that a judge has to look at in making a relocation decision. Most survivors can't pay private attorney's fees because of financial control. And unfortunately, there are many legal aid programs that just don't have the resources to represent clients in post-custody proceedings like relocation. Sometimes a relocation argument can be made at the same time as a custody case itself is filed. So someone like Lila maybe could work with an attorney in Tennessee to try and get custody and also get permission to relocate to California at that same time. Other laws may penalize the parents who do not comply with the relocation law, and that, of course, can really jeopardize children. We do want to give you some hope. There are some positive trends in case law that we've checked out across the country. Courts are permitting parents, giving parents the permission to relocate more now, and that may simply be we're becoming a more mobile society, not just in domestic violence cases, but more generally. The kinds of cases where courts are especially likely to grant relocation are if there is a criminal conviction of domestic violence by the perpetrator. And we know that this is such a small proportion of domestic violence cases, but still that has been one reason why judges in relocation cases have permitted survivors to relocate. Additionally, if there's a very specific job opportunity in the new state, that is also something that has been persuasive to judges. So not just a feeling that, oh, in my profession, IT profession, California is going to be a great place to move to, but something more specific like an actual job offer from a particular company. That's something that has helped judges to agree to relocation. Finally, judges are always concerned about maintaining the relationship between the left-behind parent and the child. So to the extent that that relationship, assuming it's safe to do so, can be nurtured through Skype or telephone visitation or holidays and summer visits, that may be something that helps judges decide to permit someone to relocate as well. And now, in a very short amount of time, I'm going to very briefly introduce you to parental kidnapping laws. But the real takeaway is please find out what your state parental kidnapping law says. It is important when you're working with survivors who want to relocate. Your law may have any of those names listed on the slide. And there may be protections for survivors in your state parental kidnapping law. So for example, California contains what's called an exemption, meaning that if a domestic violence survivor complies with the steps in the parental kidnapping law, including filing a good cause waiver before leaving the state, and filing for custody within 30 days, that person could be exempted out and not charged with parental kidnapping. Other states include what's called the defense, which is raised at a later point in time in the process, and it could be phrased as a domestic violence defense, or a greater number of states have something called a child protection defense. As so many of these cases involve parents who are fleeing in order to protect the child from ongoing physical or sexual abuse, those child protection defenses also may be helpful. The difficulty is you don't want your client to be charged in the first instance with parental kidnapping because then the children could be removed and turned over to the perpetrator, even if ultimately the survivor is acquitted. So I am going to wrap up now and ask if you all have any more questions. You can also certainly call us individually about cases you're seeing or if you have unanswered questions, and we do have ongoing training, so feel free to check our website and participate in a different training as well. We so appreciate all you do for survivors on a daily basis, and thank you for tuning in this afternoon to participate in our interstate custody and domestic violence training. Patricia, I don't know if you're able to open up the phone lines for just a minute, or we can see if we can see if there are questions. But yes, I'll put the slide up with the contact information. It's earlier in the training. We'll go back to the beginning here. And I'll just let you know, as this is taking a bit of time, our phone number is 301-270-1550. All right, well, thank you very much, everyone. Have a great afternoon.